Hello and welcome to Advocacy Essentials. This video is a part of a series of special education videos developed by the ARC of Fort Bend County and is a part of its educational advocacy program. If you would like more details about the educational advocacy program at the ARC of Fort Bend County, please visit our website at arcoffortbend.org. The purpose of this video is to educate parents, guardians, and self-advocates about the rights of children with disabilities provided by the Individuals with Disabilities Education Act, or IDEA. We hope to empower people with information and suggestions for navigating the special education process. You should know that advocacy is an ongoing process, and there is not one formula that works for everyone all of the time. What may work for one person may not work for another. We hope this video will provide some helpful insight as you consider what may be appropriate for your child, given their needs and unique set of circumstances. During this video, you will notice breaks for multiple choice or true-false questions. These questions review important concepts and check your understanding along the way. You may watch this video as many times as you like. If you have additional questions or are looking for more information about a particular topic, there are links to several helpful websites and additional resources at the end of this presentation. At the ARC of Fort Bend County, we ensure opportunities for people with intellectual and developmental disabilities to maximize their quality of life within our community. Access to a free appropriate public education, or FAPE, is an important part of equal opportunity and participation for all. We start with the definition of special education and its purpose. The Individuals with Disabilities Education Act, Part B, 2004, defines special education as specially designed instruction, support, and services provided to students with an identified disability who require individually designed instruction to meet their unique learning needs. To qualify for special education under the IDEA, a child must have at least one of 13 different disabilities listed in the statute and demonstrate an educational need for specialized instruction. When the law was drafted, Congress understood education to be more than just reading, writing, and arithmetic. This is why the purpose states that a free, appropriate public education, or FAPE, includes preparing children for further education, employment, and independent living. Special education includes what are known as related services, such as speech therapy, occupational therapy, physical therapy, counseling services, training on social skills, parent and teacher training, school health services, nurse services, and more. These related services may not be academic, but Congress recognized the importance of these services to enable children with a disability to benefit from the educational environment and increase their independence and self-sufficiency. If you suspect your child may have a disability affecting their ability to learn, you may start by talking to your child's teacher. Share the concerns you have and see if the teacher has similar ones. Has your child already been receiving extra help or response to intervention services? You should know that even if the school has provided extra help or response to intervention, this should not prevent or delay you from asking for a special education evaluation. If you suspect your child has a disability and may need special education, you should immediately request an evaluation in writing. There are several sample letters for requesting an initial evaluation, additional testing, or an independent evaluation located in the IDEA Manual 2016. A link to the IDEA Manual 2016 can be found at the link provided or on the ARC of Fort Bend County's website or via internet search. Initial evaluations can take 45 school days to complete and another 30 days to hold an admission, review, and dismissal, or ARD meeting, to determine whether the student qualifies for special education services. While the evaluation is being conducted, ask the school what it will do to help your child in the meantime. Depending on your child's needs, perhaps a 504 plan with accommodations such as extra time, class notes, or additional tutoring may be helpful. A parent's input regarding their child's strengths, weaknesses, abilities, and potential is very important. A parent is entitled to what the IDEA describes as meaningful participation. A school must make substantial efforts to ensure parents attend an IEP or ARD committee meeting. IEP stands for Individualized Education Program. ARD stands for Admission, Review, and Dismissal, which refers to the beginning, middle, and end of the special education process. Some things you can do to meaningfully participate as a parent are request to reschedule an inconvenient ARD meeting date or time, ask for a copy of any proposed goals, data, or other information that is sent to you the day before the ARD meeting, ask private doctors, therapists, tutors, or other people knowledgeable about your child to write a letter listing specific educational recommendations or strategies that would help your child in the school environment. Ask if a copy of the IEP program can be projected on an overhead during the ARD meeting so you can follow along with any changes or additions made to the IEP document. Make this request when you confirm your attendance at the ARD meeting so the school can schedule a room with a projector. And finally, speak up. If you disagree with a proposed change, would like more school or outside data on an area of concern, or time to gather more information on items discussed during an ARD meeting, let the ARD committee know. Ask for additional time and information to consider the changes before making a decision. You should never be pressured into agreeing with something you do not fully understand or agree with. When in doubt, disagree and ask for additional time and information to consider what is being proposed. Your child's school may schedule an ARD meeting, but parents may also request an ARD meeting at any time to discuss important educational concerns. ARD meetings are not a replacement for regular parent-teacher conferences. They should be used to address substantial concerns such as a pattern of decreasing grades, lack of goal improvement, concerning behavior changes, new medical, therapeutic, or evaluation data, or more. You should know that parents are not limited to only one ARD meeting during a school year. Any issues with quality or quantity of services, lack of goal progress, substantial changes in behavior, or other substantial educational concerns should be brought to the ARD committee's attention. Two common concerns parents have about their child's special education program are goals that are not challenging and lack of goal progress. If you have these concerns, ask yourself what data or information you have that supports this observation. Do teacher conferences or progress reports reflect one level of performance, but your child's abilities in other areas show a different level? If you do not already have school-based data such as class or homework samples, tests and quizzes, progress reports, or other data, request it from your child's teacher. Compare that data you gather over time. What does the comparison show you? Express your concerns in an email to the teacher in charge of the goal or subject matter. What does the teacher say in response? If there is no response from the teacher, consider emailing the assistant principal about your concerns. If you are concerned about your child's performance, remember you can request an ARD meeting at any time to voice them and discuss possible solutions. One of the best ways to organize your child's educational records and be prepared for ARD meetings throughout the school year is to have a parent's IEP notebook for your child. The parent's IEP notebook has 5 tabs: the current IEP, progress reports and report cards, the latest evaluation and therapy or tutoring notes, correspondence, and schoolwork samples. Each child should have a new IEP notebook for each school year. At the start of each new school year, transfer the copy of the most recent evaluation of your child, along with therapy or tutoring notes, over to the Evaluation tab of the next school year's IEP notebook. This will ensure you can reference the latest evaluation data available, even though your child may not receive a full re-evaluation every school year. A parent's IEP notebook is not only a great organizational tool that allows for easier goal progress tracking and ARD meeting preparation, but it also serves as an academic scrapbook to track big picture progress from school year to school year. Parents and students may reflect on what subjects, goals, and strategies may be working for their child or not. Before attending an ARD meeting, consider doing the following. Review your child's current IEP. Make a list of concerns and what you believe is and is not working for your child. Then prepare a list of proposed solutions or things you would like the school to try. Arrive a little early to the ARD meeting and bring a support person with you who also knows your child well. Bring a notepad to take notes. Ask if you may audio record the meeting. Bring any private evaluations, therapist or tutor recommendation letters with you to the meeting, and don't forget your IEP notebook. Once at the ARD meeting, allow the ARD facilitator to conduct the meeting, but don't be afraid to ask questions as they come up. If the school proposes a change or something new, gather as much information about the proposed changes as you can. Ask to see program examples. Talk to other parents whose students are already participating in the proposed program. Ask to tour the new program location and talk to the teachers. Also ask about other school district programs, services, and resources that may be available to your child. When a school proposes to change a student's educational program or the frequency and duration of a related service, this is known as a change in placement. Before agreeing to a change in placement, ask what other less restrictive alternatives have been considered to help keep the child in the current program. Are there supports and services that would help your child stay in the current program or with the current services? Have they tried providing accommodations such as extra time, tutoring, or an aide in the classroom? What data has the school collected to show the student either needs or no longer needs a particular program or service? Is the data collected an objective, norm-referenced assessment, or is it simply based on one person's opinion? What do you think about the proposed change? Do you see similar needs for your child at home or in the community? Ask questions so you are knowledgeable about all of the alternatives that may be available in order to make an informed decision. Student behavior problems are a common reason for schools recommending a change in placement. If student behavior is the reason for proposing a more restrictive environment for your child, you may want to consider the following. Are the behaviors a manifestation of your child's disability? If so, your child has additional rights that will be discussed in a moment. Are there changes in the home, family, or medication that may explain your child's recent behavior problems? You may want to share these changes with the ARD committee. Has the ARD committee met to create or revise a behavior intervention plan, or BIP, before proposing to change your child's placement? Has a school behavior specialist recently conducted a functional behavioral analysis, or FBA, to figure out why your child is having certain behaviors? A functional behavioral assessment is a comprehensive and individualized strategy to identify the purpose or function of a student's problem behaviors, to develop and implement a plan to modify the variables that maintain the problem behavior, and teach appropriate replacement behaviors using positive interventions. You should know that if your child is suspended or disciplined for behavior issues related to their disability, the ARD committee should meet to discuss how to positively address the behaviors and get the child back to the educational environment as soon as possible. If your child has been suspended or removed from the educational environment for disability-related behavior issues during 10 or more school days throughout the school year, the school must hold a meeting known as a Manifestation Determination Review, or MDR. An MDR is a special ARD committee meeting to determine whether the student's behavior is a manifestation of the child's disability or not. The MDR analysis must be performed within school days of any decision to change the placement of a child with a disability because of a violation of a code of student conduct. Under the IDEA, students shall not be disciplined for disability-related behavior or a school's failure to follow the student's IEP. However, if the ARD committee determines the student's behavior is not related to their disability and is not a failure to follow the IEP, then the student is subject to the same discipline as a student without a disability. If the MDR results in a change of student's placement to another educational setting, then the student must continue to receive appropriate educational services and make progress towards their IEP goals, even though they are in a different setting. Schools are to provide the least restrictive environment possible. They must also consider whether additional supports and services may help a child stay in their current placement. Schools are to educate a child with a disability with their typically developing peers in the general education setting to the maximum extent possible. Before agreeing to a change in placement to a more restrictive setting, ask questions and consider all the supports, services, and alternatives that may be available to your child. If parents disagree with any proposed changes to their child's IEP or program placement, they may request to take a meeting break and reconvene the ARD meeting within 10 days. The 10 days allows both school and parents to gather additional information, review the proposed program, or visit the new location and consider supports, services, and alternatives. If the school and parents still disagree about the child's IEP or appropriate program placement, parents should ensure the areas of disagreement are well documented in the IEP deliberations page. Parents should also be aware of a checkbox that would start the disagreed upon program immediately, instead of allowing the 5-day waiting period. Schools may use different programs that have various wording, but the checkbox may say something like this: Parent has been provided prior written notice and agrees to waive the 5-school-day waiting period. If parents wish to exercise their right to refuse the changes and implement stay put, they must not check the box waiving the 5-day waiting period. They must further file a due process hearing request with the Texas Education Agency within that 5-day waiting period. Stay put describes the status of the child's IEP while a legal dispute is pending between parents and the school. The 5-day waiting period allows parents time to file a due process hearing request with the TEA, but if they do not file a request for due process by the 5th school day, the school's proposed program will go into effect. A due process hearing is an administrative legal proceeding where a hearing officer will determine whether the child is receiving a free, appropriate public education, or FAPE. Parents should consider seeking legal advice from an attorney who practices special education law before pursuing a due process hearing. There are several excellent resources on special education available. You can visit the following websites for additional information or contact us here at the ARC of Fort Bend County if you have any questions. Thank you for watching Advocacy Essentials.